Thank you. May it please the court. My name is Thomas Altman. I'm the attorney representing the appellant YINZI JIN. YINZI JIN is a Chinese political refugee who on March 25th of 2009 applied for licensure as a state of Florida licensed massage therapist. On April 10th, 2009, YINZI JIN obtained her licensure, and she's practiced as a massage therapist consecutively since that date. In August of 2017, in the 9th year of YINZI's practice, she received an administrative complaint from the Board of Massage Therapy. The administrative complaint alleged violations of the Massage Practices Act, which is Florida Statute Chapter 480, and also the Health Professions Act in Chapter 456-072. The administrative complaint established two material facts that YINZI JIN admitted and did not contest, and she requested the informal proceeding to have a hearing to present her mitigating evidence. The two uncontested facts were that she had filed an application for licensure with the massage board, on which that application had a question that you had to check yes or no regarding did you have a criminal history. And the other fact is that in December 2008, she pled no contest to a battery charge stemming from an incident that had occurred on July 3rd of 2007.
That would be paragraphs 5 and 7 of the administrative complaint.
Yes, sir. The charges that ensued under the Massage Practice Act was a statute 480.046, and in the briefs I referred the charge alleged violation of 480.046 subparagraph P, and I referred to it as O, and it was a renumbering of the paragraphs, but the essence of it was that it was a provision that simply said violating a provision of this chapter or chapter 456, and the meat of the charges were contained on the allegations of a violation of 456.072 C, which was convicted or pled no contest to a crime related to the practice of the licensee's profession, and also subparagraph M, which was deceptive, untrue, or fraudulent representation related to the practice of the profession. She was not charged with the Massage Practice Chapter 480.046 specific charge of attempting to procure a license by fraud or misrepresentation, which is 480.046A, and she was also not charged under the Massage Practice Statute, same statute paragraph, but a different subparagraph C, convicted of a crime which directly relates to the practice or ability to practice. She was only charged with violating O of the Massage Practice Act, which was the catch-all, and then under the 456.072. 456.072 also has two sub-choices, subparagraph A and subparagraph H, which were not charged, and subparagraph A was fraud related to the practice of the profession, and subparagraph H was attempting to obtain a license to practice by fraudulent representation. She readily admitted the two material facts that she had indicated on her application. She filed the election of rights form on September 8th of 2017, and she requested a hearing pursuant to Chapter 120.57, subparagraph 2, for no contested issue of fact, and was afforded the opportunity to present evidence in mitigation. On April 16th, 2018, she submitted her written evidence in mitigation under penalty of perjury. That made it into the record, but it is appellant's contention that that material never made it to the board hearing, or at least was not, there's no indication it was considered by the board during the hearing. And what her mitigation response said was that she was a Chinese immigrant, that she did not write or speak English at all at the time of her arrest in July 3rd of 2007. She had taken the massage therapy courses from a school that offered them in Korean or Chinese, which were her more comfortable languages, and that when she filled out the application, in fact, it had been filled out by one of her instructors who was acting as a translator. She stated under oath in that instrument that she did not knowingly or intentionally make any omission of her misdemeanor plea, and she further stated that she had not engaged in any massage services at the time of her arrest in July 3rd of 2007. After her admission, she has practiced and renewed her license as a massage therapist numerous times without any complaints, incidents, or misconducts. Her licensure occurring in 2009 and the complaint being received in 2017, August of 2017. In the mitigation material that she filed, she also brought to the attention of the board, or attempted to in the material, she attached to that material an administrative rule which was a guideline for punishment under the applicable statute. And she advised the board that the correct disposition for omitting a criminal conviction or a plea of no contest to a misdemeanor would have been issuance of a citation pursuant to 64B7 30.004 subparagraph 3 item L, which is exactly on point, and there's a copy of that in the record at page 102. In 2016, the agency adopted that rule, and I'll read from it directly, 64B7 30.004 citations. L. Failure to disclose conviction of or entry of a plea to a criminal offense on the initial application for licensure for any licensee whose initial application was submitted prior to July 1, 2014 shall result in a fine of $500 for each conviction not disclosed on the application. In Appellee's reply brief, counsel for the Department of Health and the Board of Massage states that, well, that law didn't exist in 2007 when she was arrested, and it didn't exist in 2009 when she filed her application. That is a true statement. It did not exist prior to the amendment to those rules of June 7th of 2016. Curiously, the case number in this complaint has a 2014 number, but there's no question that the administrative complaint was not filed until August of 2017. So Ms. JIN's position is that in August of 2016, the board adopted a position that, well, if you omitted a criminal conviction on your initial application and that occurred prior to July 1, 2014, that it's a citation offense and it should result in a fine of $500, period. The authority to issue citations is found in Chapter 456.077 of the Health Professions chapter. And at paragraph 2 of that statute, it says the board or the department, if there is no board, shall adopt rules designating violations for which a citation may be issued.
Let me ask one question about,
Yes, sir.
about the Administrative Code provision 30.004 that you referred us to.
Yes, sir.
In paragraph 2, it says, in lieu of the disciplinary procedures contained in 456.072, the department is hereby authorized to dispose of any violation designated herein by issuing a citation. Your argument seems to be, as to this, that this is now mandatory, as opposed to what the language says, which is the department is authorized to do this, but it doesn't seem to make it mandatory that they use the citation and fine system as opposed to other disciplinary measures.
I would draw your attention to the next line, paragraph 3, whereby the board designates the following as citation violations, which shall is...
But that seems to have as a prerequisite the paragraph 2 issue, which is the department is authorized, but it doesn't say exclusively is obligated to issue a citation. Paragraph 3 only comes in if the board or the department proceeds with the citation option. So is there any authority for what I think is your argument that in light of paragraph 3 and paragraph 2 and 3, the board's ability to utilize 456 is eliminated? Or the discipline under 456, I should say?
Obviously, my position is yes, that was mandatory, but in support of that, I would argue that the statute which creates the authority to issue the citations is mandatory, and 456.077 says that the board shall adopt rules for violations for which citations may be issued, and the significance of that is the next sentence, where it says such rules shall designate as citation violations where there is no substantial threat to the public health, safety, and welfare, and no violation of a standard of care involving injury to a patient. If we read that together with 456.079, which are the disciplinary guidelines, subparagraph 2 says the disciplinary guidelines shall specify a meaningful range of designated penalties based upon the severity and repetition of specific offenses, it being the legislative intent that minor violations be distinguished from those which endanger the public health, safety, or welfare. And below at paragraph 4, the department must review those guidelines for compliance with this legislative intent, that the key issue being whether or not it's a violation to be considered minor based on whether it endangered public health, safety, or welfare. So another argument could be made simply that by the board issuing a citation that said, well, if you have an omission of a criminal record on an application and it was submitted prior to July of 2014, that in essence the board is finding that that complies with the requirement that there not be a public health, safety, or welfare threat, which is also referred to in the mitigating factors that I'll also argue that the board failed to consider.
So I'll go back to what I asked earlier. Is there any cases that support the argument that the discretion of the department is not unfettered. That, I mean, I understand what you're saying, but, you know, there are mays and shalls in the rules and in the statutes, and the mays seem to be winning the day as far as giving discretion to the department. So is there any case law that you found that addresses what is the scope of the discretion, and is there any limit on the discretion of the department to choose the citation versus the full hearing penalty option?
Not specifically, Your Honor, but there's certainly a plethora of case law that says if the legislative enactment states an intent in a plain language and ordinary instruction, that its plain meaning should be followed. I cannot tell you that I found a case that said the application of a citation in this instance is mandatory rather than permissive, other than pointing to the language that says the board has to designate certain violations based on the level of danger to the public, and then that they may dispose of some of them by citation. I would think the bigger point is the weighing of the risk of danger or harm to the public as a mitigating factor in what ultimate punishment is handed down. The ultimate decision was a finding that the commission of the board ultimately didn't make any findings regarding a couple of points. There was an admitted fact that a entry of a plea of no contest was entered in 2008, but there was never any finding by the board that it was a crime that related to the practice of the profession. And appellant further argues that the inclusion in the disciplinary criteria or the prohibited conduct when they offered the, for instance, when they offered in the Massage Practice Act that being convicted of a crime which directly relates to the practice of massage was subparagraph C on that. Instead, they chose O in order to string it into the 456 Department of Health statutes. Those statutes then said it had a specific one for obtaining a, here it is, 456-072 has a specific item, attempting to obtain, obtaining, or renewing a license by fraudulent misrepresentation. They did not charge that. Instead,
excuse me, Mr. Altman, you did not tell me whether you wanted to reserve rebuttal time. You're down to 4 minutes.
I'll reserve that.
Okay, fine.
Thank you, sir.
Sure.
Good morning.
Good morning.
May it please the court, my name is Christine Lamia on behalf of the Department of Health.
Ms.
There-
Lamai, the violation in this case occurred in what, 2009, the crime in 2008, is that correct?
Yes, there were two violations. The actual pleading of the battery charge was a violation, and then misrepresenting that there was a crime committed on the application was a violation.
And the penalty imposed by the board was revocation?
Yes, Your Honor, and
Did
that was,
that penalty exist in 2008 or 2009?
yes, Your Honor, and
And that would be found in 64 or whatever?
yes, Your Honor. The complaint, there's, you know, as you just mentioned, there's two
There's
violations.
two charges.
Yes, so counsel for the appellant has primarily discussed the charge relating to saying no on the application relative to a crime committed. In fact, the final order revoked based on count 2, which was the violation of committing a crime that related to the practice or the ability to practice. So I can discuss the citation issue, but I think Justice Silberman, you know, I agree with what you were saying in terms of the mays win the day, because it is in lieu of, and
Well,
this,
that charge goes to the discretion is if you're being charged with failing to report the crime as distinguished from committing a crime.
yes, Your Honor. And with that citation, the statute 456.077 does say a citation may be issued. So,
Could you help me out on something else? Because I'm
Yes.
trying to work my way, I'm sorry, at the back end of the case. I'm dealing with the revocation first, and I know it's chronologically the last thing that happened. But as I read the conclusions of law on the last page of the order signed by Kama Monroe, the second paragraph under conclusions of law has the board is empowered, and then 2 lines down says, in aggravation of the penalty to be imposed. My concern is this, and I don't know if there is a link. In civil law, if you are going to impose an aggravated penalty such as punitive damages, there's a statutory procedure that has to be followed. In criminal law, if you're going to habitualize or otherwise aggravate or enhance the sentence, we have a procedure. Looking at this, if this is an aggravation from the norm, and I understand under 14th Amendment law, your licensure has some sort of property right, so you have a right to due process. My concern is this outside the norm so that due process would require notice to the applicant that we're not just going to fine you, we're going to revoke your license that otherwise has been in good stead for the last 9 years over something that you did at the time of your application. We're going to impose a revocation. And is there anything that, or is just aggravation doesn't mean anything, it just means it's that the utmost of our original, you know, penalty. I'm trying to figure out what that word aggravation means.
yes, Your Honor, and actually that was, the wrong word was used in the board transcript. It's mitigation. Revocation is actually...
Mitigation, they said they weren't going to give her any fine.
Exactly.
They don't pay him anyway, is the way I read the transcript.
There was
Somebody
no,
said.
yes, in order to revoke Ms. Jin's license, there was no need to find aggravators in this case because the...
Penalty for crime is a revocation.
Yes, Your Honor. So the allegations of the complaint specifically set forth that crime, and the rule, the associated rule with respect to count 2 was $1,000 fine and revocation. That's what it is for battery. It's very specific in the rule. That's what it says, and that is the rule that was in effect at the time the appellant pled to the lesser charge of battery. So so we're looking at, again, 2 violations, and I'm happy to focus on the revocation issue because that really is the crux of the case. If we put aside count 1 for a moment that had a smaller fine associated with it, because...
And arguably there's disclosure about permanent revocation in the last wherefore clause.
Yes, it's
So there is
clearly...
some due process notice that this is a penalty that is on the board.
There is due process notice
I haven't
because
done
it's
any,
in the
so I'm trying
complaint.
to work my way through.
Yes, it's in the complaint. It is in the rule where if you are, you plead to battery charge, that's revocation. The issue of whether or not she answered no on the application is really kind of a subset of what actually is the crux of your decision, because the final order, in fact, revoked her license. So that's why we're here. The appellant is trying to reverse that revocation. But in fact, when you violate that statute and you're convicted of a crime and it's battery, as the rule specifically says, you are put on notice that your license will be revoked. It can't be any clearer than that. Now, in the reply brief, there was an issue that was raised trying to suggest that this issue of whether the crime was related to the practice or the ability to practice. Up until the reply brief, it was always construed, I think, by the appellant as a conclusion of law. We always construed it as a material fact. But in the reply brief, there's a mention of it being a finding of fact, which alarmed me, which prompted me to file the notice of supplemental authority of the Garrison case, because that issue was not raised. Nobody appeared at the board meeting to suggest that there was a disputed issue of fact. So that issue has not been preserved for appellate review.
There was no one from the appellant's point of view at the hearing before the board, if I read the transcript correctly. There was
Correct.
a request and there was no one responded. It didn't say no one responded, but the way I interpreted what I read was, okay, it's just us.
Yes, Your Honor. And the respondent appellate here was given notice, the opportunity to be heard, and just did not appear. The materials that were filed by the appellant's attorney at the hearing were, in fact, considered. There was a comment by appellant's counsel that he did not believe that they were considered, but it's very informative that the department's counsel actually referred to the appellant's materials during the hearing for the mitigation because she cited the rule incorrectly, which was the way that the appellant's lawyer had cited it. So it's obvious that if issues, those materials were in the record.
Let me ask a question, again, going back to the final order. Under findings of fact, the board adopted the facts set forth in the administrative complaint. And then under conclusions of law, the second paragraph, the board, the order says in aggravation of the penalty, the board cites to subparagraphs I and J of 0024. 002 talks about upon consideration of aggravating or mitigating factors present in an individual case, the board may deviate. So what I'm a little bit puzzled by is the board makes findings of fact based solely on the administrative complaint, makes no mention of the mitigating evidence that was presented, and doesn't make a factual determination as to whether it disbelieves those that mitigating evidence, whether she was lying, that the instructor didn't tell her what the question was, and maybe he put in the answer without her knowledge of it. The board doesn't reject that. And then in the conclusion, where it references the aggravation of the penalty imposed, but gives no recognition that the board considers aggravating or mitigating factors. So what are we to make of that?
Well, in order for the board to have to consider aggravating or mitigating factors, the discipline imposed would have to be outside of the guidelines. So in the first instance, it's not relevant because the revocation is within the disciplinary guideline.
Well,
the only time you would even consider that would be...
Do you agree that the board has discretion to go the citation route as opposed to the other disciplinary route?
If it's within 6 months of filing the complaint pursuant to that rule, they have discretion relative to count 1, which is the count relating to her saying no on the application. Yes.
Do they have no discretion as to the commission of the battery?
They have discretion in terms of if they want to mitigate that, they do have discretion, and they did mitigate it.
Could they use the citation rules for the battery, or are they precluded from doing so?
Well, Your Honor...
I don't read the rule as precluding them from doing so.
I wouldn't say there's an absolute prohibition against that, but the purpose of the disciplinary rules is to tie in a specific violation with a specific discipline, and that's the Board of Massage Therapy has promulgated and adopted those rules to
But
make
it's not
the penalty.
They're not exclusive. They do not eliminate the department's ability to use the citation form of, if I'm wrong, tell me, because I was trying to find what discretion does the department have in terms of the type of discipline that's being pursued and the discipline that's ultimately being imposed. And so this ties into, as opposing counsel pointed out, there's some qualifiers based on public health, safety, and welfare. There are qualifiers based on mitigation and aggravation. And so I'm trying to get a handle on what degree is the department's discretion encumbered in some way.
Okay, let me just refer you back to the rule that was in effect at the time that the violation was committed. And this is 64B7-30.002, and I'm going to read from paren 1. When the board finds that an applicant, apprentice, or licensee whom it regulates under Chapter 480 Florida statutes has committed any of the acts set forth in Sections 480, and it cites two out of the two of the statutes we're referring to, 480.046 and 456.072. It shall issue a final order imposing appropriate penalties within the ranges recommended in the following disciplinary guidelines. Okay, so just reading that part, it's a shall. So they shall...
But they have the discretion as to the nature of the penalty, don't they? I mean, I thought
well,
what you just read, within the range of
under
appropriate...
subsection C, Your Honor, it specifically references 456.072 paren 1 paren C, which is the charge under count 2, crimes relating to battery, $1,000 fine and revocation. So if you read, the first sentence that I just read to you, you go down to crimes relating to battery, it is $1,000 in revocation. That's what it is. And yes, they have discretion, but the discretion comes in with the aggravating or mitigating factors. If you read the rest of that sentence, it says, after consideration of the aggravating and mitigating factors set forth in subsection 3, which is now subsection 4 in the current rule.
That's my point. While revocation and the fine may be, they're clearly authorized, the question becomes, is the language as to aggravating and mitigating factors surplusage that has no impact, or is there the ability to mitigate?
No, Your Honor. In fact, in this case, it was mitigated. The fine was not imposed.
So the mitigation that I understand she argued included no harm to public welfare, safety, and so forth, and that she didn't really intend to mislead, which I understand is the first of the two charges. But in terms of the commission of the battery, does the department have discretion? Does it have authority to say under these circumstances, revocation is not required? That doesn't fulfill the purposes of the statutory scheme and the rule scheme. Do they have that discretion?
If they have mitigating circumstances that would support that,
let's first answer the question. Do they have discretion?
Yes.
All right, so now going back to the final order, where the order only references aggravating, well, there are two things that I pointed out. One is the findings of fact only refer to the administrative complaint, not the information that she provided as an offer of mitigation. And so the findings of fact don't reject the credibility and don't make findings that it is credible or incredible. They don't address it. And then the second conclusion talks about aggravating, nothing specific about mitigating. So I guess what I'm driving at, is there a lack of findings that enable us to determine, did the department in fact consider and reject her mitigating evidence? Because that, if there was a finding saying we don't find it credible, that might have disposed of this case, but there's no finding to that effect. Is it implicit? Is it inferential? What do we do with that?
Well, if you go back to the board transcript, it is discussed in there. The fact
discussed,
that
but
it
there's
didn't
no
make it into the final order is, you read those together. I don't have case law on that now, but if Your Honor would like me to provide that to you, I can at a later date. But, so it was, the mitigating factors was discussed. It was referred to by the department's counsel when she miscited the rule, because she was referring to the respondent's materials.
The fact that it was brought up and the only mitigation was related to the fine, your position is that's enough to demonstrate they knew they had discretion and they chose to exercise it the way they did?
Well,
Or is there more?
first of all, the Board of Massage Therapy has multiple cases within a 2 to 3 day period when they meet. They meet quarterly. There could be over 100 cases. They have all of the materials for every case in a board packet. So they have all of
I
that.
understand they have the information in front of them. What I'm puzzled by is the adoption as the findings of fact, the facts set forth in the administrative complaint, and no sentence that says, and we reject as mitigating, or we reject it as sufficiently mitigating, or we reject it as to credibility concerning what was before them, what you just conceded was before them in mitigation.
So, but putting it in the context of the board meeting, the board applies consistent discipline to its licensees. And even as they were talking about that in this board meeting in terms of the consistency that they want to apply. And when they have these many cases, when they see a violation of a statute and there's a corresponding rule, they apply what the guideline is.
So are you suggesting they do not consider mitigating factors?
No, I'm not suggesting that. What I'm suggesting is
So
that they did consider
are there
it.
other cases out there that are on all fours with this one, where the individual claims to not be proficient in English, relied on someone else, claims that she relied on someone else, inadvertently made a misrepresentation? Is there a plethora of cases that are identical to that you're saying are on all fours, and this is consistent with those?
Well, Your Honor, you're forgetting about her pleading to the battery charge, which is a direct application.
I'm not forgetting it. Again, I'm going back to, does mitigation play a role? And
Yes, Your Honor, it
it's either yes or
does.
no, and you're saying yes, it plays a role, but there's no finding in the findings that relate to mitigation. It only refers to aggravation, and it only refers to the facts in the complaint, not the facts that she tendered in support of mitigation.
Okay, so in the rule, it does say shall, and then it refers to the factors for considering aggravating or mitigating circumstances, and under that subsection, which at the time it was subsection 3, not 4, but in any event, based upon consideration of aggravating or mitigating factors present in an individual case, the board may deviate from the penalties for the violations charged.
So what in the final order reflects consideration of the mitigation evidence that was offered?
There's no specific writing in the final order. The board transcript shows that it was considered, but it's not specifically written in the final order.
It shows that it was considered, or it shows that it was mentioned? I mean, I
Well,
know
it's
they
in
have
the board
materials.
packet.
I know they have the materials. That doesn't mean anyone read them. Well, you hope they did, and we might presume they did, and there was mention of mitigation. But again, all I'm driving at is the specific findings that indeed were made.
Well, and I'd like to go back to the complaint, which the final order does find the factual allegations of the complaint, because the complaint is very clear. It specifically alleged that and this is in paragraph 4, on or about July 3rd, 2007, the respondent was arrested for the unlicensed practice of health care. So that right there has been admitted at the time of the hearing. So just reading that in and of itself, there's no real, argument that this respondent, this licensee, was arrested for the unlicensed practice of healthcare. So then also to admit that there's a charge of battery, and then there's a corresponding rule. Really, the board was not required to do any more than it did. It could have, it had the mitigation documents that were filed, partly confusing because the mitigation documents that were filed had cited the wrong rules and the wrong statutes on almost every occasion. So, the board doesn't have to rely on something that's incorrect, certainly. But the fact that the board adopted the findings of fact that are in the administrative complaint it's very clear that the paragraph, the allegations in the complaint specifically allege what the violations are. The appellate admitted that, and that's what they looked at the disciplinary rule, and they entered revocation because it says that for a crime of battery that the discipline is $1,000 fine or revocation. They decided not to fine her.
We're right at the end of your time, so I wanted to ask, do the disciplinary rules have a prescribed penalty for being, if you're convicted of providing healthcare services without a license?
They most likely do, Your Honor, but I don't. It's about a 6-page rule, so I'd have to go through it.
Okay, don't worry about it.
Okay.
When we look at it with the Chief Judge's indulgence, 30.002, that's what we're looking at for disciplinary guidelines?
Yes.
Okay. One of the sections says, based upon consideration of aggravating or mitigating factors present in an individual case, the board may deviate from the penalties for the violations charged. Is that the discretion to which you refer?
Yes, Your Honor.
Okay. And then there's a listing from small a to n about what those factors may be. And I think the point that Judge Silverman may be going to is, how do we know from looking at this very short hearing over a course of 100 days that they were actually in fact considered? Is it an inference to be drawn from the fact that there was no fine? I mean, I think that's what he's saying. If we have, the last one says, any other mitigating or aggravating circumstance. Because you look at some of these factors, the length of time since the violation, the number of times the licensee has been disciplined, the effect of the penalty upon the licensee's livelihood, the actual knowledge of the licensee. Some of those factors mitigate in favor of, arguably, depending upon how one weighs it, a lack of revocation, right? And how do we know if they looked at those things? Because this violation, the battery, took place before she even applied.
Well, we know that they were in the board's packet because of the stamps on the board packet. It would almost be, how do we know that a judge looks at all the evidence that's been admitted during a trial? It is part of the record below. So that's, I mean, I can't stand here and say, I know they looked at every piece of paper. I wasn't there, so, but it is in the record.
What you know is they're supposed to. And
I know that they do, because I've gone to those board meetings, and I know that they do, and I know that it was referenced as referenced in the board transcript.
Okay, so your time is up, Mr. Lang.
Okay.
Ms. Lang. Thank you.
Thank you.
Thank you for correcting my failure to reserve. I appreciate it.
No problem.
Counsel stated that in the mitigating factors provided that we made no argument that the crime didn't relate to the practice of massage therapy or massage. And looking at the record, page 87, on paragraph 8 of the respondent's written evidence in mitigation of the complaint, respondent states under oath, respondent has never been convicted of or entered a plea of guilty or no contest to any crime in any jurisdiction which relates to the practice of massage therapy or the massage profession. And as Justice Casanueva just indicated, or just...
I haven't been promoted to that level yet. I'm merely a judge.
I'm sorry, Judge, my mistake.
Okay, I'm
As the
flattered,
judge
but-
said, this crime occurred well before the licensure. So one question we'd have to get by is whether or not the statute was even violated, which was to my point that the 072 materials gave other more pointed violations, such as in 480.046, there's a choice C that could have been made, and that says being convicted or found guilty regardless of adjudication of a crime in any jurisdiction which directly relates to the practice of massage. I think counsel's making a jump from admitting the fact that you were arrested for massage therapy to the equivalent of being convicted of a crime that related to massage therapy. It's even more compelling to say that, well, since she was arrested for practicing the massage therapy without a license, and that was never prosecuted. I mean, she was arrested July 3rd, 07, and then in December 08, they kicked her loose with a lesser included misdemeanor of battery. I can tell the court, it's not before you, but misdemeanor battery is not a lesser included charge of practicing medicine without a license. Curiously, if you look at the felony information that was filed against YINZI JIN, it accuses her, and under the judge's, above the judge's signature, it accuses her of practicing podiatry without a license, which, I'm sorry, optometry. It was a different profession. The fact of the crime having to be related to the practice is not established by what it was arrested for. There's nothing in the statutes or the code that says being arrested for 56072 subparagraph 1C, which is the one counsel's focusing on, and I don't know if she's abandoned the application oversight, but she seems to focus more on the fact of the crime itself. 4560721C says being convicted or found guilty or entering a plea of no contest. Here she did enter a no contest plea, but to battery, not to practicing medicine without a license. So you can't equate the allegation in the complaint where it says she was charged with practicing license without practicing medicine in her health profession without a license to saying she was convicted of that. In fact, the exact opposite is true. The record reveals that she was incarcerated on July 4th of 07, and she was later released in December of 08 after languishing there in county jail for all that time. There's been no finding by the board as revealed in the order in relation to the, this relates to the practice or the ability to practice a profession.
Hey, Mr. Altman, you need to wrap up your time's up.
Thank you, sir. I think that the designation of C requires that you already be in the board's jurisdiction as either an applicant or a licensee when the crime occurs. And in this case, that was not present.